Good day everyone, this is Julian G. Bularin from Group 2 and I will be presenting the second part of Chapter 6, which is Insolvency of Individual Debtors. This chapter typically pertains to the insolvency of individual debtors within a legal or financial context. It likely outlines the procedures and regulations concerning the handling of debts and assets in such cases. So here we have three mechanisms or process of handling the insolvency of individual debtors. So we have suspension of payments, voluntary liquidation, and involuntary liquidation. So first we have suspension of payments. So this refers to when an individual seeks to temporarily hold payments to creditors while restructuring their finances. And then second, we have voluntary liquidation. This occurs when an individual debtor decides to voluntarily wind up their affairs and distribute their assets to creditors. And lastly, involuntary liquidation. This occurs when creditors petition the court to force an individual debtor into liquidation due to their inability to pay debts. Under suspension of payments, so it encompasses sections starting with Section 94 petition, Section 95 action in the petition, Section 96 action suspended, Section 97 creditors meeting, Section 98 persons who may refrain from voting, Section 99 rejection of the proposed agreement, Section 100 objections, Section 101 effects of approval of proposed agreement, and Section 102 failure of individual debtor to perform agreement. And under voluntary liquidation, so this only encompasses two sections, which is Section 103 application and Section 104 liquidation order. And lastly, under involuntary liquidation, we have Sections 105 Petition Act of Insolvency, Section 106 Order to Individual Debtor to Show Cause, Section 107 Default, Section 108 Absent to Individual Debtor, Section 109 All Property Taken to be held for all creditors, appeal bans, exceptions to sureties, and lastly, Section 110, sale under execution. So since Section 94 to 100 were already discussed by the previous reporter, I will be tackling Sections 101 to 110 for this chapter. Section 101 effects of approval of proposed agreement. So this section outlines the effects of approving a proposed agreement during a creditors meeting in cases of insolvency of individual debtors. If the majority of creditors approve the agreement, or if there are no objections, the court will order that the agreement be carried out, binding all parties involved to comply with its terms. The court has the authority to issue necessary orders to enforce the agreement upon the motion of any affected party. However, the order confirming the approval of the agreement will not bind certain creditors, such as those with claims for personal labor, maintenance, or expenses related to the debtor's family in the 60 days before filing the petition, as well as secured creditors who did not attend the meeting or abstained from voting. This ensures that certain creditors are not unfairly affected by the agreement. Section 102, failure of individual debtor to perform agreement. In this section, it becomes evident that it serves as a safeguard in case the individual debtor fails to fulfill the terms of the agreement approved during the creditors' meeting. In such an event, all the rights that the creditors had against the debtor before the agreement will be restored to them. This means that creditors regain their ability to pursue the debtor for the debts owed. Additionally, it mentions that the individual debtor may be subject to insolvency proceedings as outlined by the Act. Essentially, this section reinforces the importance of adherence to the agreed terms and the potential consequences for failing to do so, emphasizing the legal recourse available to creditors in such circumstances. Section 103. Application. So this section establishes the process through which an individual debtor with insufficient assets to cover their liabilities and owing debts exceeding 500,000 pesos can seek discharge from their debts and liabilities. To initiate this process, the debtor must file a verified petition with the court of the province or city where they have resided for at least 6 months prior to filing the petition. Along with the petition, the debtor must submit a schedule detailing their debts and liabilities as well as an inventory of their assets. Importantly, the act of filing this petition is considered an act of insolvency. This section outlines a formal avenue for individuals facing overwhelming debt to seek relief through the legal system, providing specific criteria and procedures for eligibility and application. Section 104. Liquidation Order. This section specifies the immediate action taken by the court upon finding the debtor's petition to be sufficient in both form and substance. Within 5 working days of this determination, the court is mandated to issue the liquidation order as mentioned in Section 112 of the Act. This underscores the expeditious nature of the legal process in response to a debtor's petition for discharge from debts and liabilities. By swiftly issuing the liquidation order, the court initiates the formal proceedings necessary for the orderly resolution of the debtor's financial obligations. Section 105. Petition, Acts of Insolvency. So this section expands on acts of insolvency that warrant filing a petition for liquidation by any creditor or group of creditors with claims totaling at least 500,000 pesos. These acts include intentional departure from or absence from the Philippines to defraud creditors, concealment to avoid legal process or hinder liquidation, concealing or removing property to prevent attachment or legal process, allowing property to remain under attachment to hinder liquidation, confession or offering of judgments to hinder liquidation or defraud creditors, willful default judgment to hinder liquidation or defraud creditors, procuring property to be taken in legal process to give preference to certain creditors, making assignments, gifts, sales, or transfers of property to hinder liquidation or defraud creditors, making payments or transfers of property in contemplation of insolvency, defaulting in payment of current obligations for 30 days if a merchant or tradesman, failing to pay monies deposited or received in a fiduciary capacity after demand for 30 days, and lastly, being unable to satisfy a judgment due to insufficient property subject to execution. Additionally, the petitioning creditors must post a bond determined by the court, ensuring compensation to the debtor for costs, expenses, damages, and attorney's fees if the petition is dismissed, withdrawn, or if the debtor is not declared insolvent. This section provides a comprehensive framework for creditors to address instances of insolvency and protect their interests through legal recourse. Section 106, Order to Individual Debtor to Show Cause. This section details the legal process following the filing of a creditor's petition. The court issues an order directing the individual debtor to appear and demonstrate why they should not be declared insolvent. The time and place for this showing are determined by the court. Additionally, the court has the authority, upon showing good cause, to issue an order prohibiting the debtor from making debt payments or transferring any property they own. However, it's important to note that this does not diminish the rights of secured creditors to enforce their liens as per the terms agreed upon. Essentially, this section outlines the steps taken by the court to compel the debtor to justify their financial situation and address potential measures to safeguard creditors' interests during the insolvency proceedings. Section 107, Default. Section 107 stipulates the consequences if the individual debtor defaults or if, following a trial, the court finds in favor of the petitioning creditors. In either scenario, the court is mandated to issue the liquidation order as referenced in Section 112 of the Act. This underscores the legal outcome of a default by the debtor or a favorable ruling for the petitioning creditors, which initiates the liquidation process outlined in the subsequent section. It emphasizes the legal mechanism through which insolvency proceedings progress following a default or a court decision in favor of the creditors. Section 108, Absent Individual Debtor. This section addresses situations where the individual debtor is absent from the Philippines, has departed from the country, cannot be found despite due diligence, or is intentionally concealing themselves to avoid legal proceedings. In such cases, the petitioning creditors can seek an order from the court for publication and present a bond amounting to double the total sum of their claims against the debtor. This entitles them to an order directing the sheriff to seize a sufficient amount of the debtor's property to satisfy the creditor's demands and cover the costs of the proceedings. Essentially, this section outlines the legal recourse available to creditors when the debtor is absent or intentionally evading legal processes related to insolvency proceedings. Section 109, All property taken to be held for all creditors. Appeal bans. Exceptions to sureties. This section outlines the procedures regarding the custody of property taken by the sheriff in cases of insolvency. If the property seized does not encompass all of the debtor's non-exempt assets, other creditors can seek similar orders by providing a bond approved by the court, double the amount of their claims. This allows for fair distribution of assets among all creditors. The bonds provided must ensure compensation for damages suffered by the debtor if the court decides in their favor with the amount determined by the court. In cases of appeal, the appellant must provide a bond double the value of the property in question and cover the costs of the proceedings. Any interested party can challenge the sufficiency of the sureties on these bonds. If challenged, the petitioner's sureties must justify their sufficiency within a specified time frame. Failure to justify or replace insufficient sureties may result in the court vacating the order to seize the debtor's property or denying the appeal. This section ensures transparency and fairness in the process of handling debtors' assets during insolvency proceedings. And lastly, Section 110, Sale under Execution. This section outlines the procedure for selling the debtor's property under execution during insolvency proceedings. If proper affidavits and bonds are submitted to the court or a judge, along with an order for publication and custody of the debtor's property, and it is demonstrated to the satisfaction of the court or judge that selling the property would benefit the parties involved, the court may order the sale of the property. The sale would be conducted in a manner similar to property sold under execution, with the proceeds deposited in the court to await the outcome of the proceedings. This section provides a mechanism for realizing the value of the debtor's assets to address creditor claims in insolvency cases while ensuring transparency and fairness in the process.